Good evening, everyone, and welcome to the grand final of the Herbert Smith Freehills Moot competition for spring 2021. My name is Amy Shao, and I'm the president of the Western Sydney Law Students Association for 2021. It is my pleasure to welcome you to this event, and before formally opening and introducing you to the judges for this competition, I would first like to give an acknowledgement of country. The Western Sydney Law Students Association acknowledges the peoples of the lands upon which we are meeting today. We acknowledge that the teaching and learning currently being delivered across our campuses is a continuance of the teaching and learning that has occurred on these lands for tens of thousands of years. We pay our respects to elders past, present, and emerging of these nations, and extend that respect to all other Aboriginal people present. We acknowledge our gratitude that we share this land today, our sorrow for the costs of that sharing, and our hope and belief that we can move to a place of equity, justice, and partnership together. It is my pleasure to introduce the judges for this competition, those being the Honourable David Collier, a former Justice of the Family Court of Australia, and Ms. Suhair Adelby, who is a lecturer at the School of Law of Western Sydney University, and also relevantly the unit coordinator for the contracts unit upon which the law for this moot competition is based. So without further ado, I'll then be handing over to Mr. Collier.
Thank you. We only seem to have, yes, we're all here. I don't propose to try and talk about the rules to any extent. You've all read the documents. I will ask you 4 appearances, and your senior will introduce himself and his junior. I do propose to ask you how you propose to share the 30 minutes. And hopefully you'll be able to tell me. I would imagine, probably both of you would work 50-50, but that's a matter for you. But I would like you to be able to tell me. Does anyone have any questions before we start? I have received and read both your sets of written submissions, and I will return to those shortly. So may I have the appearances, please?
May it please the court, my name is Tran, initial A, T-R-A-N, and my learned colleague is Miss Turner, T-U-R-N-E-R, initial A.
Thank you, Mr. Tran. And for the respondent?
My name is Miss Duncombe for the record, D-U-N-C-O-M-B-E, and I appear with my learned junior, Mr. Nguyen, N-G-U-Y-E-N.
Thank you. Mr. Nguyen, are you there?
Yes, Your Honour.
Are you going to come on?
Yes.
Coming back to you, Mr. Tran, what are your proposals for the sharing of your allocated time?
Our speaking time will be 15 minutes each between me and Miss Turner.
Thank you. And for your side, Ms. Duncan?
The respondents in addressing the court will speak both for approximately 15 minutes each.
And certainly no more. Very well. Mr. Tran, are you ready to proceed?
Yes, Your Honour.
You're going to timekeep for us, Ms. Shah?
That's correct.
Then, in your own time, Mr. Tran.
The case for the appellants is this: that Amazement Turnaround Proprietary Limited, through their television broadcasted advertisement, induced Mr. Johnson, a person suffering from cancer, to buy and use their product, believing his cancer would be cured. At $1,000 a unit, with no alternative use other than it literally cures cancer, the respondents have engaged in conduct that is against the spirit of the Competition and Consumer Act. The structure of our submissions is as follows. The respondents engaged in misleading or deceptive conduct. The advertisement has a statement intended to be relied upon and was not mere puffery. The contract contained unfair terms, and the respondents engaged in unconscionable conduct. From here, the orders sought by the appellants include allow the appeal and an order for costs. If your honours have no questions as to the structure of our submissions, I will begin with the issue of misleading or deceptive conduct.
Please go on.
The respondents' advertisements contain the following representations. The catchphrase, "It works like wonder, it works like nothing else. Come join quickly and all your problems will be solved." followed by the appearance of gloomy people quickly turning joyful after using the product, and the testimonial, which stated the product literally cures cancer and that the buyer felt so much healthier and happier after using it. We submit that the testimonial, the product literally cures cancer, is misleading or deceptive and has induced Mr. Johnson and cancer-suffering consumers into buying their product. In the absence of any warnings or disclaimers contrary to this statement, we submit that the onus should be on the respondents to provide these warnings. The first element of the Competition and Consumer
I'm
Act.
sorry. When
Yes,
you
Your Honor.
say the onus, what do you mean?
The onus to provide warnings to their claim.
Is that onus or obligation?
Yes, Your Honor, obligation.
Thank you. Please go on.
The first element of the Competition and Consumer Act, Schedule 2, Section 18(1) of the Australian Consumer Law, that is, the element of trade and commerce, should be satisfied as the advertisement was in the nature of selling the respondent's products. Your Honor, I seek leave to refer to a case not expressed in my written submissions. That is the case of Butcher and Lachlan Elder Realty Proprietary Limited, 2004, Volume 218 of the Commonwealth Law Reports, from pages 592 to 625 at pinpoint 109 by Justice McHugh.
Why should that leave be granted?
If leave is granted, this should cause no prejudice or detriment to the respondents, as they have made reference to it in their written submissions.
Do you wish to be heard on that at all, Ms. Duncan? It would appear to me if it's in your written submissions, you can hardly object to it.
Yes, Your Honour. I believe that I relied on Butcher in my appellant submissions, not necessarily in my respondents. I don't have it. I don't actually refer to it in my oral submissions today. I might have it there as a reference, but I definitely did refer to them in my appellant submissions. I'm happy for the appellants, however, to refer to the case.
Yes, please go on, Mr. Trent.
Thank you, Your Honor. And if I may, dispense with formal citations from here
You
onwards.
may.
The case of Butcher and Elder Realty provides that in order to assess whether conduct is misleading or deceptive, it is necessary to identify its likely effect on the audience to whom the conduct is directed. The respondents have made these representations to the public at large by way of television advertisements, a target market recognized in the ruling of RNC Products and SC Johnson & Sons, 1994. The fleeting message that the product literally cures cancer is a buzzword used by the respondents to catch the attention of people who know someone who has or is suffering from cancer themselves, where television advertisements should be assessed on an impressionistic basis, as per the rule of Pacific Dunlop and Hogan, 1989. Therefore, this representation that the product literally cures cancer can isolate members of the general public to those who suffer from cancer or their loved ones. The Australian Cancer Foundation has stated that 1 in 2 Australian men and women will be diagnosed with cancer by the age of 85. Members of this class should be perceived as distressed and desperate and should be protected. We submit that the use of a testimonial is misleading, as the specific words literally cures cancer has misled Mr. Johnson into the error that the product literally cures cancer. Deputy Chair Dr. Michael Shaper of the ACCC has said that fake testimonials can mislead consumers and disadvantage competing businesses. This is from a media release from the ACCC, where a removalist company paid for penalties for alleged false or misleading online testimonials. Although this is in relation to online testimonials, I submit that this should be also extended to any form of testimonial, as the reassurance an attestant can create is the capacity to lead consumers into error. Dr. Shaper further states that consumers should be able to trust that testimonials online are posted by genuine consumers about genuine experiences. In the case of ACCC and Advanced Medical Institute 2006, the defendants were found to be in contravention of Section 18 of the ACL by way of a fake celebrity testimonial, where the celebrity claimed his impotence was cured when he used their product. It was later found that the celebrity neither suffered from impotence nor used their product. The importance of this case is that the specificity of the testimonial closed off any other interpretation other than if the consumers use the defendant's products, their impotence would be cured. Although the interpretation of the testimonial at hand does not positively suggest that the attestant suffered from cancer or used their products in connection to cancer, the onus should be on the respondent to provide a simple disclaimer or warning that the attestant did not. This warning could have been provided at any or all mediums that has conveyed the product, that is, the television advertisement itself, the phone line which is stipulated at the end of the television advertisement, and the website to which the consumer was redirected to by way of pre-recorded message. The only warning or disclaimer provided is buried within the contract of membership, which stated, the buyer agrees that in the event that any sickness or ailment is not cured, no action whatsoever shall be brought against the seller. I submit that the interpretation of this clause is merely a safeguard against liability and not a disclaimer to the assertion that the product literally cures cancer. Furthermore, the clause should be interpreted in support that the intended use of the product is to cure an ailment, and the only ailment expressed to be cured is cancer. There is no alternative use of the product that is expressed in the advertisements. Wellness products are capable of being identified by marketing buzzwords such as mood boosting or dopamine producing. It is a reasonable reaction to be joyful and happy if oneself or another was cured of cancer. Therefore, I submit that Mr. Johnson and sufferers of cancer and their loved ones were led into the error that the respondent's product would cure their cancer because of the testimonial and lack of any warnings or disclaimer to this claim. I will now address the issue of puffery. I submit that the testimony literally cures cancer cannot be interpreted as a mere sales puff due to its specificity. The case of REA Group and Fairfax Media provides examples of where the specificity of a claim results in the broader claim being more than just puffery. Where in this case, defendants stated that they had more listings in Sydney than any other comparable app or website. The defendants had a qualifying statement in its fine print contrary to this claim. However, Justice Murphy at 144 stated that the fine print must be sufficiently prominent to be likely read by an ordinary consumer. The specificity of this claim literally cures cancer should have and was not made contrary in fine print or disclaimer. I further submit that the testimonial cannot be construed as an opinion of the attestant, but as a statement of fact, as a testimonial is a voluntary claim and not a statement provided as an answer to a question by Mr. Johnson. Although a case from New Zealand, Bissett and Wilkinson, 1927, the distinction drawn from an opinion and a statement of fact within a transaction should be followed.
Mr. Tran, are you prepared to tell me what you say the disclaimer should have said?
Your Honour, the disclaimer should have provided a warning to say...
No, I'm not asking you what it should have provided. Are you prepared to tell me what you say it should have said, not what it should have contained?
Yes, Your Honour.
Please do.
The disclaimer should have said, contact your healthcare professional before using this product, or the product may not cure all cancers.
Thank you. Please go on.
I submit that if Your Honours find that the testimonial may amount to puffery, this should not defeat the finding of misleading or deceptive conduct on part of the respondents due to the character of their commercial behaviour. The case of ACCC and K at 122 for Justice Kenny supports a submission, as the defendant in this case made claims that his consumers would become millionaires in 12 months if they followed his real estate investing program. Justice Kenny noted that newspapers are read by a wide spectrum of the public, including the intelligent and wary, and also by the unsuspecting, the gullible and the impressionable. I submit, Your Honour, that even if the testimonial should amount to puffery, the fact that it was broadcasted to the general public by way of television during prime time airing, and the lack of any prominent disclaimer to the claim that the product literally cures cancer, should find that the respondent engaged in misleading or deceptive conduct. If I can be of no further assistance, my learned colleague will address the issues of the contract and unconscionability.
Will your learned junior tell me the orders that you seek, or do you propose to do that?
Yes, Your Honour, I believe I have addressed that. The orders we seek include to allow the appeal and an order for costs.
Now, you said include. That leaves, to my mind, something else. Is there anything further that you would seek?
No, Your Honour, just those two orders.
Thank you. I'm sorry, bear with me for one moment.
Yes, Your Honour.
Thank you, Mr. Tran. I have nothing further. Ms. Turner, are you ready?
I am, Your Honour.
Then again, in your own time.
I will now address the matter of unfair contract terms and unconscionability. While we concede Mr. Johnson is bound by the terms of the contract, I submit that the majority of these terms are unfair as per the Competition and Consumer Act 2010 Commonwealth, Schedule 2, Section 24, Subsection 1. I now request leave to dispense with formal citations for the duration of these submissions.
That leave is granted.
Thank you, Your Honour. As a standard form contract, the contract in question is subject to the unfair contract provisions in the Act. Section 24, subsection 1 provides that contract terms may be unfair if they create a significant imbalance in the rights and obligations of the parties, if the terms are not necessary to protect the legitimate interests of the business, and if the terms cause financial detriment to the consumer. In regards to the legitimacy limb of this test, Section 24, subsection 4 of the ACL states, a term of a contract is presumed not to be reasonably necessary in order to protect the legitimate interests of the party who would be advantaged by the term, unless that party proves otherwise. It is therefore the respondent's responsibility to establish why an unfair term may be legitimately required. Section 24, subsection 2 provides that the court may take into account such matters as it thinks relevant, but must take into account the transparency of the term, as well as the contract as a whole. Section 25 provides examples of terms that may be unfair. I will now consider each of these clauses with reference to this test. Firstly, Clause A, which provides that a basement turnaround has discretion to terminate this contract as and when it deems most appropriate. This must be read in conjunction with Clause B, which provides that the buyer may terminate at will, given 14 days notice and payment of 1 month's fee. Section 25C of the ACL describes a term that penalizes or has the effect of penalizing one party, but not another party, for a breach or termination of the contract as potentially unfair. I submit that these clauses create a significant imbalance in the rights and obligations of the parties. Where the respondents may terminate the contract at any time to no detriment, Mr. Johnson is obliged to provide notice and a $500 cancellation fee. In support of this submission, I refer to the ACCC and CLA Trading Proprietary Limited 2006. Justice Gilmore at 54 stated that a significant imbalance requirement is met by the granting to the supplier of a beneficial option or discretion or power by the imposing on the consumer of a disadvantageous burden or risk or duty. I submit that by combination of the free discretion afforded the respondents in termination and the disadvantageous burden of termination fees imposed upon Mr. Johnson, a significant imbalance is created. Furthermore, this clause clearly imposes a financial detriment of $500 upon Mr. Johnson. I would draw the court's attention to the ACCC and Crisco Hampers Australian Limited 2015. This analogous case dealt with the cancellation fees imposed during lay-by agreements. Justice Edelman held Section 97, subsection 3 of the ACL requires that, at the time of termination, a supplier must not charge a termination charge that exceeds its reasonable costs in relation to the agreement. While this provision referred to lay-by agreements, I submit it may be used as reference when considering the difference between a reasonable and excessive termination fee. While it is for the respondent to prove the legitimacy of this fee, I submit there is no evident justification for this detriment to be imposed upon Mr. Johnson. With these matters balanced and considered, I submit that clauses A and B clearly satisfy the unfair terms requirements laid out in the ACL. Clause D provides that Amazement Turnaround may introduce new products to replace existing products, and the buyer agrees to be bound to the new products. Section 25, subsection G of the ACL suggests this may be an unfair contract term. In essence, this term allows the respondents to alter their products without cost or detriment, while any consumer is duty-bound to accept these products or pay the $500 cancellation fee. The term does not even provide that a consumer will be notified of such a change. I refer again to Justice Gilmore's previously mentioned quote, in support of the submission that this disparity in duty satisfies the significant imbalance requirement. This clause imposes both a practical and financial detriment upon Mr. Johnson. Practically, many medications require consistent usage for optimal efficacy, to say nothing of potential quality changes in the product. Financially, should he not wish to receive the changed products, Mr. Johnson would experience a detriment of $500 with no corresponding benefit. I therefore submit this term also satisfies the unfair terms requirements laid out in the ACL. Clause E is an exclusion clause that provides, in the event that any sickness or ailment is not cured, no action whatsoever shall be brought against the seller. Section 25, subsection K of the ACL describes a term that limits or has the effect of limiting one party's right to sue another as potentially unfair. I submit this exclusion clause is extremely destructive to Mr. Johnson's statutory and common law rights, while being extremely beneficial to the respondents. The respondent's product was marketed as improving health, yet contractually, they seek to be obliged to no duty whatsoever in that regard. I submit this refusal of duty towards Mr. Johnson is too significant an imbalance to be justified. This clause creates a significant detriment to Mr. Johnson's legal rights and to his ability to recover damages for potential detriment to his health that may be caused by reliance upon this medication. I therefore submit this term also satisfies the unfair terms requirements. As for the matter of transparency, it is true the contract terms were easily accessible before Mr. Johnson's acceptance and reasonably transparent in wording. However, transparency alone does not defeat a finding of unfairness. In support of this submission, I refer again to the ACCC and CLA Trading Proprietary Limited 2016. Justice Gilmore at 54 stated, the legislation proceeds on the assumption that some terms in consumer contracts, especially in standard form consumer contracts, may be inherently unfair, regardless of how comprehensively they might be brought to the customer's attention. Finally, in considering this contract as a whole, I submit the examined terms are not counterbalanced by any others that provide benefit to Mr. Johnson. Each clause presents another instance of unfairness from which there is no respite. To conclude, analyzing each of the relevant terms and with consideration to the contract as a whole, I submit these terms more than satisfy the ACL's requirements for unfair contract terms. I further submit that the judge at first instance erred in finding Amazement Turnaround not liable for unconscionable conduct. Section 21 of the ACL subsection 1 provides a person must not in trade or commerce in connection with the supply or possible supply of goods or services to a person engage in conduct that is in all circumstances unconscionable. Unconscionable conduct is further defined in Hurley and McDonald's Australia Limited, 1999, by Judge Dowsett at 22 as unfair or unreasonable behaviour, irreconcilable to what is right. In ACCC and Sealer-Fridge 2010, Judge Logan states at 12, providing such conduct should be evaluated by reference to normative standards of conscience and accepted community values. In order to establish this was an unconscionable bargain, we'll further refer to the test laid out in Turner and Windever 2003 at 105. Firstly, this test provides that a weaker party must suffer a special disadvantage vis-à-vis the strong party that seriously affects the weaker party's capacity to judge or protect their own interests. Mr. Johnson had that day been diagnosed with signet ring cell adenocarcinoma. Medical studies suggest the overall median survival time for those diagnosed with this type of cancer is a mere 12.7 months, and the 5-year survival rate is only 9.4%. This news came without warning nor time to prepare, as Mr. Johnson was by all accounts a healthy individual. No amount of education can be expected to mitigate the emotional effect of a sudden confrontation with one's own impending mortality. This diagnosis created an extreme emotional vulnerability that seriously affected his capacity to protect his own interests against false promises of health and longevity. In support of this submission, I refer to the ACCC and New Era
I
Health.
interrupt you just for one moment, Mr. Henry, I'm sorry. And you say that it absolves him, my word, from any requirement to read the terms of the contract?
Your Honour, I would submit that this particular emotional vulnerability is severe enough to be considered a special disability.
Thank you. Please continue.
In support of this submission, I refer to the ACCC and New Era Health Proprietary Limited 2007. It is a highly analogous case in which New Era Health was found to have exploited cancer victims with false representations and exploitative contract terms. Justice Ryan at 7 described the behaviour as a consistently cynical and heartless exploitation of cancer victims and their relatives when they were at their most vulnerable, acknowledging the intense physical and emotional vulnerability of cancer victims. Both precedent and common community values support the submission that an individual suffering a life-threatening and likely terminal illness is placed in such an intense, emotionally vulnerable state as to potentially endanger their own interests. The second limb of the test requires the stronger party must know of the special disadvantage, or know of facts that would raise that possibility in the mind of any reasonable person. This principle is echoed in Commercial Bank of Australia and Armadio 1983, in which Justice Mason stated at 461 that the test is satisfied when the other party knows, or ought to know, of the existence of that condition or circumstance and of its effect on the innocent party. The Cancer Council of Australia states 1 in 2 Australian men and women will be diagnosed with cancer by the age of 85. This is a huge proportion of the community. Mr. Johnson's experiences are tragically common. I submit a reasonable person would consider the possibility their advertisement, specifically purporting to cure cancer, would be seen by those suffering cancer. I submit the respondents knew, or ought to have known, their supposed puffery would catch the attention of a class of people who are suffering from cancer, and that these people are in a state of desperate vulnerability.
So in effect, you would say they were targeting this class of people?
Your Honour, were they not directly targeting this portion of the community, they should at least have considered their advertisement would reach this portion of the community. And the final limb of this test provides further clarification on that issue. The final limb is that the stronger party must take unconscientious advantage of the opportunity presented by the disadvantage. It is not the advertisement alone that is unconscientious, nor the manner the contract was presented. I do not submit the respondents in any way forced Mr. Johnson into their unfair contract terms. However, I do submit that their absolute lack of care taken with potentially vulnerable clientele, with no disclaimer of any kind, is where advantage has been taken. In support of this submission, I refer again to the Commercial Bank of Australia and Armadio. Justice Dean at 474 stated that an onus is cast upon the stronger party to show that the transaction was fair, just, and reasonable. The respondents made no effort to ameliorate the disadvantage suffered by those to whom their products were marketed or would obviously be seen. There was no suggestion Mr. Johnson should seek further medical advice, nor any effort made to ensure his treatment was suitable for him. Instead, the respondents enjoyed the benefits afforded by Mr. Johnson's disadvantage, profiting off medications they knew could not do what they were advertised to do. I submit that the content of the advertisements, the refusal of duty towards their clients, and lack of disclaimers constitutes a system of conduct that is unconscionable. While Mr. Johnson is the singular victim in this case, this pattern of behaviour could affect many more consumers. Indeed, any of the 50% of our population suffering from cancer that may see this advertisement broadcast on television during prime evening hours. To conclude, at every step of their interactions with Mr. Johnson, the respondents have been dishonest, irresponsible, and predatory. Their advertisements were misrepresentative of their product. Their conduct was deceptive. The terms they offered Mr. Johnson are inherently unfair. Their behaviour is unconscionable. For these reasons, we seek the appeal be allowed and costs be ordered. If I can be of no further assistance, that concludes my submissions.
Unless my sister has any questions, thank you, Ms. Turner. I'm greatly assisted. Now, Ms. Duncan, are you ready to proceed, or would you like a short adjournment?
I'm happy to proceed, Your Honour.
Very well. In your time.
Thank you, Your Honours. May it please the Court. The matter before the Court today serves as a timely reminder between the demarcation of a consumer and company and the company's right to strategically market their products without legal implications. In the course of my oral arguments, I'll be addressing grounds 1 and 2 of the appeal, and my learned junior will be addressing grounds 3 and 4. In light of our intended submissions, the respondent seeks the following orders. Firstly, that the appeal be dismissed in its entirety. And secondly, that the appellant pay the respondent's costs of and incidental to this appeal. In addressing ground 1 of the appeal, I submit that the judge at first instance was correct in finding the advertisement contained a sales puff. Your Honours, I direct you to the decision of the Queen's Bench, the 1893 case of Carlyle and Carbolic Smokeball and Co., Volume 1 of the Queen's Bench, starting at page 256. Before I proceed, may I please dispense with formal citations?
You may.
Thank you, Your Honours. Your Honour. This case has received full judicial support in the decision of Ackers and Oscorp International Limited, a federal court decision in 2009 in Australia. In that case, Justice Rares at paragraph 167 discussed Carlyle and Carbolic and said that courts have long employed common sense in determining whether or not a statement is a mere puff. In the case of Carbolic, Justice Bowen held that an advertisement must be read in its plain meaning. It was intended to be issued to the public and to be read by the public. How would an ordinary person reading this document construe it? In that case of Carbolic, it was a written advertisement that outlined that there would be a £100 reward for anyone who uses their product in accordance with their conditions. It also contained a passage that there'd be £1,000 deposited at a bank, showing their sincerity in the matter. In that case of Carbolic, the court found that because of the specificity of language and the £1,000 showing the sincerity, it showed that there was a promise being made and it was not mere puffery. I submit that the present advertisement was issued to the public and was to be watched by the public. Therefore, in order for this court to ascertain whether it contained a sales puff or a statement intended to be relied upon, the court must consider how would an ordinary person watching this TV advertisement construe it. In the case of Stewart, Justice Lockhart at paragraph 164 held that the public is accustomed to the puffing of products in advertising. I submit, Your Honour, that the phrase, "It works like wonder, it works like nothing else, come join quickly and all your problems will be solved," is mere sales puff. I submit that an ordinary member of the public who is watching this advertisement would be accustomed to the puffing in sales advertisements heard on TV. The phrase, "It works like wonder," is a general exaggeration that is not specific. What is wonder? How is that defined, if not to be an adjective used in sales puff to draw in the attention of a wide consumer base into the advertisement? The phrase, "all your problems will be solved, Your Honours," I submit that here there is a lack of definitive and specific language being used. In the case of carbolic, specificity in language being used was considered heavily by the court. They found that the specific directions on how to use the carbolic smoke ball and the fact that they mentioned that the £1,000 was deposited at the bank expressed that there was a promise to be made. In our case, Your Honours, I submit that the phrase, "all your problems will be solved," is not specific. It would not portray to a wide audience that this was a statement intended to be relied upon. I submit that it is mere puff due to the fact that the phrase, "all your problems," does not actually tell the person watching the advertisement specifically what problems would be solved, nor does it specify what solved means or how it would be solved. The use of the word "all" is also ambiguous, and using common sense, I submit that a person of the public watching this advertisement would recognise that all of their problems can't be solved. It's such a minute possibility. Unlike carbolic, where people were instructed how many times and how long to use the product for, it was very specific, whereas in this case, the advertisement used language that was too broad and was a sales strategy aimed to target numerous customers into watching the ad for the duration. Additionally, Your Honour, I do submit that the testimonials included in this advertisement that it literally cures cancer and that the buyer felt so much happier and healthier after using it are also sales puffs. As I mentioned earlier, Justice Rares in Ackers at paragraph 167 said that the courts have employed common sense in determining whether a statement is a mere puff or not. I submit that a person watching this TV advertisement using common sense would understand that cancer is an incurable disease. I also submit that the combination of the word "literally" before "cures cancer" adds to the exaggeration of the phrase "cures cancer," as an ordinary person in today's society would know that the phrase "literally" is used to convey an exaggeration rather than a statement of fact. I submit that a phrase "it cures cancer" or "cancer will be cured" is less of an extreme sales puff than "literally cures cancer." I submit, Your Honour, the next phrase in the testimonial that the buyer felt so much happier and healthier after using the product was again sales puff, as the language is not precise. This is a subjective statement that to an ordinary person watching the advertisement, they would understand that their own experience may differ from the testimonial or the person that's saying this testimonial. The fact that happier and healthier are not measurable things, especially in combination with the word "so much," indicates that the words is sales puff, used to draw people into listening into the advertisement, as they are broad statements that many Australians would want to feel. Who wouldn't want to feel happier and healthier? But using common sense, many advertisements would use this catchphrase to target a broader audience and thus increase their sales. I would also like to submit, Your Honour, that in carbolic, the court placed reliance in the notion that £1,000 was deposited in the bank to show their sincerity in the matter. I submit, Your Honour, that in this case, the respondent did not place any money in assurance for what they were offering, nor did they tell people in the advertisement that anything that was being said was a statement to show their sincerity. I submit that distinguishable to carbolic, where there was specific language being used and a reward amount placed in the bank, in the present case, there is no specific language being used, and it was broad and general claims with exaggerated phrases such as "literally," "all," and "sales," and "so much." Your Honour, when watching this advertisement in its plain meaning, I submit that as a whole, it contains statements that are sales puffery. The advertisement used general language with exaggerated superlatives that to an ordinary person, when hearing them said, would understand that they are not statements to be relied upon, but sales puffs. In addressing ground 2 of the appeal, Your Honour, I submit that the trial judge did not err in finding that the respondents did not engage in misleading and deceptive conduct. The Competition and Consumer Act 2010, section 18, subsection 1, holds that a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or likely to mislead or deceive. Your Honour, in the case of ACC and Coles, Justice Alsop at paragraph 38 held that for an inquiry under section 18, it is necessary to identify the impunged conduct and then to consider whether that conduct, considered as a whole and in its context, is misleading and deceptive or likely to mislead or deceive. In the case of ACC and TPG, the court held that when trying to ascertain the mental impression created by a number of representations in one communication, it is wrong to attempt to analyse the separate effect of each representation. As such, Your Honour, I submit that the impunged conduct in this matter was the television advertisement as a whole, which includes the visuals, the statements, and the customer testimonies. In ascertaining whether there has been a contravention of section 18, the target audience must be analysed. In the case of Nike International, starting at page 45, the High Court held that when conduct is directed to the public at large, the court must consider whether those representations are untrue so as to mislead a hypothetical, ordinary, and reasonable member of a class of potential purchasers. In the present case, it's the respondent's submission that the target audience would be a potential purchaser of Amazement's products from the general public, and potentially someone who is looking for a product that could improve their countenance or well-being. In establishing misleading or deceptive conduct, the case of Coles cited TPG at paragraph 45 and held that the dominant message of the advertisement must be given regard in analysing a statement. The case of WTH and Budget Rentals held that impressions gained by a viewer of a television advertisement, such as this, are not only from the spoken word, but from visual images in conjunction with the spoken word. It is the overall impression that matters. The court in TPG went on to say that when conduct is misleading or deceptive or likely to mislead or deceive, this occurs when there's a tendency to lead into error. In that case of TPG, it was an advertisement that prominently displayed an offer for broadband internet for $29.99 a month. Much less prominently, they did qualify this offer, saying that you could only have it when it was bundled with a home phone provided through TPG and it incurred an extra cost. The court held in that case that the fact that customers might only absorb the dominant message was not a consequence of selective attention, rather it was an unremarkable consequence of TPG's advertisement strategy. In that case, the tendency of TPG's advertisement to lead consumers into error arose because the advertisement themselves selected some words for emphasis and relegated the balance to relative obscurity. In our present case, Your Honour, I submit that the dominant message displayed by the visuals and words in combination in this advertisement to a member of the general public is that this product can make a person feel generally healthier and happier or improved in some way. The facts before us do not state that the visuals showed improved countenance of a severely sick person or a person suffering from cancer. It was a general person who, from just using the product, noticed an improved countenance. The spoken statements in the ads, Your Honours, contain general and broad statements with words such as, your problems would be solved, you will feel happier and healthier, to convey to the audience the dominant message that this product works in a holistic way. There will be a wide range of benefits and varying degrees of countenance improved depending on the recipient. I submit that Amazement's marketing strategy was honest and it did not lead a consumer into error. This is due to the fact that the visuals and the statements in combination were broad and general. Unlike the case of TPG, where the marketing strategy selected some words for emphasis to portray and offer favourable in the mind of the viewer, and that led them into error, the advertisement in this case did not highlight only certain words. Instead, it was the dominant message being conveyed that by using this product, you could have a range of overall well-being improvements, such as an improved countenance, or you may feel certain degrees of happiness or health, or your health being improved, or have a certain problem solved. The dominant message portrayed and mental impression created was that by using this product of Amazement's, your well-being could be improved in a range of broad ways. The case of TPG went on to say that this legislation, Section 18, does not operate for the benefit of those who fail to take care of their own interests. I submit, Your Honour, that Mr. Johnson failed to take care of his own interests. His interest as a cancer patient would be in trying to cure his cancer. However, The dominant message portrayed by this advertisement was not such to suggest that it would cure a signet ring cell carcinoma, which is the rare form of cancer Mr. Johnson had. This cancer has a survival rate as low as 9% over 5 years. In the alternative, a reasonable person with cancer or a person related to someone with cancer, i.e. the general public, whom is the target audience, would appreciate that cures for cancer do not exist. And if they did exist, they would be provided by the treating physician. Although the advertisement did contain words that it literally cures cancer, I submit, Your Honour, that these words were not misleading or deceptive as to lead a person into error. As a general member of the public, whom is the target audience, would have the common knowledge that cancer, let alone the specific type that Mr. Johnson had, is an incurable disease, and as such, they could not be misled or deceived by them, as it is common knowledge. I submit, Your Honour, that overall the conduct of the advertisement was not misleading or deceptive under Section 18. The advertisement's dominant message was that the product can improve one's overall countenance or to some degree make you feel happier or healthier or have certain problems solved. And as such, Your Honour, I submit that there was no contravention under Section 18 and I urge the court to uphold the trial judge's findings. If Your Honour has no further questions, that will complete my submissions.
I do have two.
Yes, Your Honour.
You've spoken about this really being an advertisement that addresses general unwellness, if I can put it that way,
Yes, Your Honour.
and ways of improving it.
Not necessarily, you don't necessarily have to be unwell in order to use the product. It's a well-being product. So you could be of proper health and wanting to just have some, as I stated, happiness is not a measurable thing. So just some improvement, but you don't necessarily have to be sick in order to see an improvement. That's more a subjective internal feeling.
Then why go to the almost ultimate extreme of mentioning cancer?
Yes, Your Honour. The ultimate extreme of mentioning cancer in the customer testimony was placed in there to potentially broaden the advertisement's audience. That was a customer testimony, which was the person's personal experience. So that customer who was in the product may have had their cancer cured. They might believe so subjectively. And as such, Amazement decided to put that in their advertisement as a testimony, noting the fact that obviously people who of the general public with common sense would know that their own experience may not be exactly the same to someone who's in a testimony, because experiences differ from person to person.
And my second question, what allowance, if any, should have been made or should be made for Mr. Johnson's condition of newly discovered significant cancer have upon him not having read the conditions and done what he perhaps ought to have done? Can he be excused for that? Can his duty of self-care be written down because of that? Or is that just something simply to be ignored?
Are we, Your Honour, are you talking in regards of whether the advertisement is misleading or deceptive, or are you talking about the fact that he didn't read the terms and conditions under contract?
I'm terribly sorry to interrupt you. I'm talking about the second, the fact that he didn't read them. Does he get, as it were, any allowance because of his then recently diagnosed illness?
Yes, Your Honour. I believe my learner junior will be addressing that in his submissions in regards to whether or not you have to read contract terms.
Then say no more.
Thank you, Your Honour.
Any questions from my sister?
No, not at the moment.
Thank you. Then thank you for your assistance. Mr. Nguyen, you're ready to proceed, or would you again like a short adjournment?
Your Honour, I'm ready to proceed now.
Thank you. In your own time.
Thank you. May it please the court. If the appeal were to be allowed today, it begs the question as to what rights and protections are afforded to corporations such as the respondent. I'll make two principal submissions today. The first of which closely follows on from my senior, and it is that the trial judge was correct in finding the terms of the contract were fair and that the appellant was bound by them. My second submission is that it was open to the trial judge to find the respondent did not engage in unconscionable conduct. Your Honours, I'll firstly address your second question directed to my senior in that whether the appellant should have been bound by the terms. I turn Your Honours' attention to paragraph 3.1 of our written submissions. It is my submission the appellant was bound by the terms of the signed wrap agreement, having accepted the terms of the agreement which were readily available. I rely on the authority of Dialogue Consulting Pty Limited and Instagram Incorporated, a 2020 decision of the Federal Court of Australia, judgment number 1846. Your Honours, at this point in time, I seek leave of the court to dispense with full citations.
Leave is granted.
I'm most grateful, Your Honour. Your Honours, in Instagram, the court held users were bound by internet contracts as Instagram provided users with constructive notice of the existence of these terms, and that by clicking sign in, they were assenting to the terms. Likewise, my client's landing website clearly directed the appellant to the terms and conditions. It was not hidden or discreet. In fact, it was transparent. It was the first thing that the appellant saw when he clicked on the website. The appellant then made positive actions to click on the accept button, much like in Instagram. Therefore, it is my submission, Your Honours, that the appellant was bound by these terms. I trust that answers Your Honours' question directed to my senior.
Not quite.
Yes.
If you were clicking on for Instagram, what were you expecting to get?
Your Honour, do you mind repeating that? You cut out there?
You've used the example of Instagram.
Yes, Your Honour.
You've talked about clicking on.
Yes, Your Honour.
What was the benefit to be obtained by clicking on?
Yes, Your Honour. Your Honour, the benefit to be obtained by clicking on is that in Instagram, the plaintiff had in fact acknowledged that they've read the terms and conditions. And more specifically, the clause at issue was an arbitration clause in that matter.
No, please. My question is, what was the benefit to the litigant clicking on? What did he obtain for it?
Yes, Your Honour. Yes, Your Honour. He obtained the knowledge that he had read the terms and conditions. And
No, that's not what he obtained. By entering into the, I will use the expression contract.
Yes, Your Honour.
By on, what did he stand to get?
Yes, Your Honour. I now understand your question and withdraw my previous
I'm
comment.
sorry if it was badly phrased.
No, Your Honour, it was my internet. Your Honour, it is my submission that the benefit the appellant gains in this matter is
I'm sorry, you're still not answering my question.
Yeah.
What did the person in Instagram
Yes.
as a benefit to him by clicking on?
Yes, Your Honour. Your Honour, the factual scenario in Instagram is that the litigant was intending or was asked by Instagram to work as a client insofar as managing their social media interactions. So the benefit there was that the Dialogue company obtained a client in Instagram, being a large corporation, Your Honour, and that is the benefit.
Is that the same benefit as clicking onto something that you might, however far-fetched it might be, have a belief might save your life?
Yes, Your Honour, I note that Your Honour's reference to save your life, but the advertisement by my client in paragraph 14 of the questions for clarification merely states it was a wellness product and did not guarantee any cure of cancer or disease, Your Honour. So the benefit he obtains here.
It doesn't give a guarantee. I accept that absolutely.
Yes, Your Honour.
But does it not give rise to the belief that for a desperate person, there may be a prospect that it can cure it?
Certainly, Your Honour. And I will make submissions on that ground in unconscionability as to the position the appellant found himself. If Your Honour would like
to sit quietly and let you go on.
Thank you, Your Honour. I'm most grateful. I now turn the court's attention to paragraph 3.2 of our written submissions. And it is my submission that clause B was a fair contractual term under sections 23 and section 24 of the Commonwealth Competition and Consumer Act of 2010. Clause B is a termination clause which purports to impose a 14-day notice period along with a payment of 1 month's fee. As to the first limb of an unfair term under section 24, subsection 1A, it is our submission clause B does not cause a significant imbalance. My submission relies on the distinction of the case in ACCC against ACN, a 2015 decision of the Federal Court, found at footnote 15. In ACN, NRM had offered treatments for premature ejaculation and erectile dysfunction. Their consumer contract included a refund term requiring the payment of a 15% administration fee, as well as a pro rata fee for the 30-day notice period, as well as the cost of medication supplied. However, my client's termination clause is not as onerous as the one in ACN. My client has only requested 1 month's fee, which is not as large as the 15% required in the authority I rely on. Further, my client has only asked for 14 days notice, and he has not asked for a pro rata fee within those 14 days. Accordingly, it is my submission clause B of the contract does not cause a significant imbalance in the parties' rights. I turn now to the second limb under section 24, subsection 1B, and it is my submission clause B was necessary to protect the interests of the respondent. I rely on the authority of ACCC and CLA Trading. In that case, Justice Gilmore held it was necessary for Europcar to require their customers to pay all reasonable costs to return the car to its original conditions. This is analogous to the present case. My client operates a business model where it forecasts its capital growth based on its membership. When a new client joins, my client's capital forecast is adjusted to account for profits from the new client. When a client purports to terminate the contract, my client must offset its underwriting losses by asking for those 14 days notice and 1 month's fee. The additional 1 month's fee is necessary to cover the cost of closing the departing member's account. Therefore, Your Honours, it is my submission that clause B is necessary to protect the interests of the respondent. I do concede that clause B causes a financial detriment as the kind described under section 24, subsection 1C, but it is my overall submission that the unfair term claimed by the appellants fails on limb 1 and 2. I now turn the court's attention to clause E of the contract, which is an indemnity clause. While clause E does indemnify the respondent from any action, the indemnification was not significant in terms of the contract as a whole under section 24, subsection 2B. In the case of Ballard and Sebring Pty Limited, found at pinpoint 19, the operation of the exclusion clause meant a renter of a truck was not able to claim insurance for damage. But there was no significant imbalance because the plaintiff had the opportunity to hire a different vehicle from Europcar. Likewise, the appellant in this matter was not forced to purchase the wellbeing product and sign up to the membership. He willingly and voluntarily accessed my client's website. According, Your Honour, is my submission, clause E did not cause a significant imbalance. Your Honours, I note I do have 5 minutes remaining, and I ask the court to rely on my written submissions as to the second limb of clause E, as I move directly to unconscionable conduct. Your Honours, My submission of unconscionable conduct is found at paragraph 4, and it is that the primary judge did not err in finding the respondent's conduct did not amount to unconscionable conduct. Your Honours, it is here that I refer back to your question earlier in my submission as to the special disadvantage that the appellant finds himself in. Your Honours, I note the moot rules allow me to refer to cases in my opponent's submissions, and I rely on CBA and Amadio, which is referenced in my client's written submissions. The court in CBA and Amadio held that for the first limb of equitable unconscionability to be successful, the client must be in such a position so as to not appreciate the circumstances he finds himself in. However, I seek to distinguish CBA and Amadio where the plaintiff parents were uneducated and illiterate. In this case, at paragraph 1 of the facts, it states the appellant was an engineer. A reasonable inference may be drawn from this fact that the appellant was of high education. Secondly, I refer to the questions for clarification where it states that the client may have been distressed. I emphasize the use of the may. The court cannot reasonably, on balance, find that the appellant was so distressed that he was concerned for his life. That does not meet the threshold required as for a special disadvantage alluded to by Your Honour earlier in my submissions.
You say no fear for his life. He had just, now let me finish.
Yes, yeah.
He'd just been diagnosed with a cancer with a 9% chance of survival.
Yes, Your Honour. I do note that my friends have referred to a 9% survival rate. However, it is my submission that 9%
But your
survival.
leader did.
Yes, Your Honour. Yes, Your Honour. It is my submission that this 9% survival rate only occurs after the first 5 years. 5 years after having this signet cell carcinoma. And therefore,
what's your authority for that?
Your Honour, my authority for this, I am unable to assist the court as this has not been in any judicial decisions, merely it's in medical reports, Your Honour.
But you're giving me a medical statistic.
Yes, Your Honour. In that case, Your Honour, I withdraw my submission and instead submit that it was incumbent on the appellant to speak to his medical physician and determine whether he was in fact about to pass away. There is nothing on the facts to suggest his medical physician said that he might die. This is merely an assumption by the appellant, a subjective assumption, which under section 21 of the Act, the court need not have regard to subjective circumstances of a single consumer. My authority for that is the federal court case, or the full court federal case of Unique International. Your Honour, I know I do have 1 minute remaining, and I do seek leave of the court to use the full 5-minute extension referred to in paragraph 5.2 of the moot rules.
I will grant that extension.
I'm most grateful, Your Honour. Your Honours, I now turn back to my primary submission on unconscionable conduct, in that this assessment under section 21 is to be assessed objectively, and it is my submission the conduct of the respondent does not fall so far outside societal norms of acceptable behaviour. In the case of ACCC and Phoenix Institute of Australia, the federal court held it was unconscionable to fail to properly assess potential students who were signing up to the defendant's training courses. However, it is our submission that the facts of the case before the court today are distinguishable. In Phoenix, the training provider had 378 students. A reasonable inference may be drawn in that this was a manageable amount of students to interview. Contrastingly, it is implied my client's advertisement has been broadcast to Australia as a whole. Implicitly, there will be thousands of clients signing up to respondent's membership program. In the alternative, it was at least broadcast to New South Wales. As my client only has 21 employees, it would not be a reasonable expectation to interview each and every single interested party to the wellbeing product. It is therefore my submission that Contemporary Australian Society would regard the respondent's advertisement as right and proper. Furthermore, it is the respondent's submission that the alleged conduct did not amount to an unconscionable system of conduct under section 24, I withdraw that, under section 21, subsection 4 of the Act. In addressing my submission, I seek to distinguish the case ACCC and Unique International. This is the federal court decision, Your Honour. The court held Unique International College had engaged in a system of conduct or pattern of behaviour by first, specifically targeting disadvantaged people, secondly, using gifts of laptops and iPads, and lastly, the use of incentives to staff to encourage students to sign up. However, my client has offered no consistent incentive to sign up people to their membership program. There was no offer of a complimentary product of any kind, merely a membership program. Further, unlike an international, Unique International.
Wasn't there an offer of good health?
Yes, Your Honour. Indeed, there was an offer, but it is not the kind that's offered in Unique. In Unique, a laptop was offered. That is a tangible property. The offer in my client's case was merely, was no tangible asset offered to the clients. And I trust that answers Your Honour's question. And thank you, Your Honour. Your Honour, and unlike an Unique International, the advertisement was through television. Due weight must be given to the fact it was not a personalised approach, like in Unique. And whilst the advertisement was designed for people who had cancer, or in the alternative, people generally for wellbeing products, it was not specifically broadcast to them. It was broadcast to the country as a whole. Accordingly, it is the respondent's submission that the alleged conduct did not amount to an unconscionable system of conduct. In the alternative, as I alluded to before, Your Honour, evidence of the appellant alone is insufficient to establish a system of unconscionable conduct. Evidence of additional consumers of my client's product must be adduced to satisfy section 21, subsection 4, and I rely on the authority of Unique International, the full court decision. My final submission is that my client did not engage in any conduct that involved unfair pressure. I direct Your Honours to paragraph 4.4 of my written submissions. I rely on the authority of Veal and Director General. In Veal, the company represented itself as an agent assisting men to find romantic partners. They used tactics such as emotional manipulation by belittling men and humiliating them for being single. Contrastingly, in my client's advertisement, it did not contain any negative comments. And therefore, it is my submission as a whole that my client did not engage in any unconscionable conduct. Your Honours, to summarise the respondent's submissions, it is our submission that firstly, the advertisement did not contain a mere sales puff. Secondly, the respondent did not engage in misleading and deceptive conduct. Thirdly, the terms of the contract were fair. And finally, the respondent did not engage in unconscionable conduct. Your Honours, it is therefore our submission the appeal be allowed and the appellant pay the respondent's cost of and incidental to the appeal. Should Your Honours not follow us on our submissions, we seek that this court substitute a verdict in light of the doctrine of a just, quick and cheap resolution of disputes, as you have had the opportunity of hearing evidence on the substantive issues. If I can be of no further assistance, that completes my submissions.
Tell me again what you say the outcome should be, Mr. Newton.
Yes, Your Honour. The outcome, I know my time has expired. I seek leave to answer your question, Your Honour.
Of course you may have that time.
I'm most grateful, Your Honour. Your Honour, our first order that we seek is that the appeal be dismissed in its entirety on all four grounds.
Now stop for a moment. You realise that only moments ago you said the appeal should be allowed.
Yes, Your Honour, I withdraw
that was
comment.
a slip of the tongue.
Sorry, Your Honour?
That was a slip of the tongue.
Yes, Your Honour, that was a slip of the tongue.
Now, tell me what you say the outcome should be.
Yes, Your Honour, it is our submission that the appeal be dismissed in its entirety. And secondly, that the appellant pay the respondent's cost of and incidental to the appeal. And those are the two orders that we seek today.
I understand.
And if I could be of no further assistance, that completes my submissions.
Thank you, Mr. Nguyen. I'm grateful.
Thank you. Thank you, Your Honours.
Now, the show.
All right. So now we'll move the competitors into a breakout room and we'll call you back when the judges have reached their decision.
Take a long time.
Moving them over now, and I'll also just pause the recording.
Hi, everyone. Welcome back. Thank you so much for your presentations. It was a joy to watch. You all did extremely well. And we have some feedback for each individual speaker. Before I give my feedback, and I'll limit my feedback to the performance, and perhaps David will speak to the legal issues. So perhaps to start, I'll just let you know that the winning team is the appellants.
By a very narrow margin.
Yes, very narrow margin. So please bear that in mind. And with that, I might just jump into the feedback for Alec Tran. Can't see Alec. There we go.
There he is.
Yep, there he is. Alec, really good job. Well done. I know a moot is not easy. I've done them myself and it's really, you feel very pressured and you have the time constraint. I really enjoyed your presentation, but some feedback and the main feedback I have for you really relates to your presentation and in particular your voice. I know that you've probably been given advice to really slow down in your presentation. But for me, the pace could have been just a little bit faster in order to make it a more engaging experience for us, the judges, perhaps. But I think in order also that might allow for more variation in your voice and for a projection of that as well. At times, I think, and I can understand the reason why, because you needed to really slow down and make your points very clear. But at times, your voice became a little bit monotonous. So perhaps in future, that you can adjust that a bit, but you had really excellent eye contact all the way through. And the other feedback that I have for you is you really hung on the words, what were they? Literally cure cancer. And you really made a lot about that. But there was a lot of repetition as a result. And so I don't think you needed to really bang on about that point too much. I think you could have just made that point and then moved on to develop your argument. Instead, I think sometimes you really just kind of you really limited yourself in a way to just letting us know how bad that statement was, where you could have gone further. And I know you could have done that. You obviously showed very wonderful potential to do that. But I know that probably the nerves got you as well. But otherwise, I think you really presented very well, and you had a very clear structure all the way through as well. So well done.
Thank you very much.
You're welcome. And now is it Rayanne?
It's rain like the weather.
Rain like the weather. Beautiful. Rain, I really enjoyed your presentation. You had a really clear voice, and when you came on, it projected so well, and it was very engaging, and a really good pace as well. So well done. You did a great job with the presentation, and also with the legal arguments. I think you handled them with sophistication, and I especially liked your arguments around unfair terms, and I found them very persuasive. I think you were really good with both presenting those arguments and with the legal analysis as well. So well done. Did I have something else? there's probably a lot of things I can say, but all good. Yeah, I really also, I think towards the end of your presentation, you started to talk about the pattern of behavior, and you suggested that there was some, systemic abuse perhaps. But I didn't think you really needed to go that far. I think you already had a really solid and persuasive argument. So you didn't need to reach out further and overstretch that argument. So I would probably pay attention to that, when we get into these arguments, there tends to be a risk that we will overclaim. But to hold back and just stick with your core arguments, because they were excellent and very persuasive. Yeah, so well done. Now to Brittany. I really enjoyed your presentation, and just kind of found you very engaging with your feedback. I'm just gonna fix this. Really engaging, a really kind of, your voice was really easy for me to listen to. So yeah, I could just listen easily all the way through. And you had a really good projection of your voice, lots of variation, really great tone as well, all of which helped me to understand and be able to follow your arguments. I really thought that you were very persuasive in your arguments. And one thing I liked that you did was in demonstrating your reasoning, and particularly in distinguishing your case from the legal authorities that you were talking about. So in Khalil Kabolik, obviously a central case around sales puffery, you really highlighted for me, and really I found very convinced me about why this was a different scenario to that. So really good job with that. And also in highlighting the fact that, in saying that not all problems can be solved. This is, incurable, and just flagging that, I thought really kind of helped me to understand your own position and your legal analysis. And also, I really liked how you set out the fact that the ad was advertised in very broad and generalized terms. And you stuck with that, but you went further in sort of demonstrating how and why that was. And I thought that was very compelling. And I just loved your use of Khalil and the carbolic smoke ball. And I love that case. So I really liked how you took your time to kind of analyze that. Yeah, I mean, the rest of the comments that I had really fall under that feedback. So really good voice. Thank you. It was a pleasure.
Thank you very much for the feedback.
Now, I don't see your junior counsel's first name.
It's Rodney.
Rodney.
Yeah.
Okay, great. Thank you. Where are my notes? So you also had a really engaging presentation and a really good, strong voice that projected well. And for some reason, I just found that very useful, because we're doing this on Zoom rather than live. But really good projection of voice that helped me to follow along and come along with your arguments. I think, though, perhaps you got a little bit stuck with answering some of the questions from His Honour, and I know that they weren't easy questions to answer at times, and you were being asked to address the question, so that was important, and I think that perhaps let you down a little bit. So yeah, I mean, I think you probably could have, I know you could have handled those questions better, but under the pressure and the nerves and the time constraints, very understandable. And then towards the end, I think you really set out your core arguments, and they were good. And then you started to overstretch, I think, some of those arguments. So I think sticking to your core arguments and not trying to overclaim is really important, because then it looks like you're just getting desperate and you're not really, your submissions don't seem as focused as they could be. And I think also towards the end, I think all you really needed to say to make your point was that the terms were very clear, that they were, incorporated, and that the appellant had to take certain steps before he even entered into the contract, and kind of leave it at that. I don't think you needed to do much more than that to make your point. What else do I have here? And I really did appreciate your point about the contract being a standardized contract, not a personalized approach. I thought that was really interesting and clever. And it made me appreciate the complexity of this fact scenario as well. So thank you. But a good presentation. Don't be disappointed with yourself. Some of those questions were difficult to answer. I probably would have struggled too. You did well in the circumstances. So yeah, well done. And that's probably it from me. I'll now see if His Honour would like to give some comments too.
I would. Look, you all should be pleased with yourselves. It was a good effort. One of the things that I was impressed with was the work that you'd obviously done both in the written and the oral presentations that you made. Sue-Ann was only going to talk about the presentation, but she spoke about the law. So I'm going to get back at her and speak about the presentations. Starting with Mr. Tran, I liked your structure. That will come as no surprises between you and I. I thought you spoke well. I thought you started what was clearly going to be a complex argument by telling us fairly effectively, or very effectively really, and early in the piece, what was going to happen, and making, I thought, full use of the fact that the appellant had been diagnosed with very serious cancer and casting, as it were, some sort of, not overglow, but this must have had some effect on the way he was thinking and the way he was acting. And I think that was perfectly proper in these circumstances. I've always liked the way you speak. I think that you spoke at a good pace, and with respect to my friend, I thought that you were just emotive enough in your use of language. I thought that you were clear to follow in your arguments on the law. I thought the way you used some of the false advertising cases was entirely appropriate, and the way you dealt with the puffing aspect from Carlisle. I swore once I'd finished legal studies, I'd never hear of that case again, but there you go. I thought you dealt with the questions well. I thought that you made the appropriate concessions and you answered the questions as they were asked, which I find something to be important because it shows not only are you reading from a script, but you have an understanding of the underlying matters which enable you to deal with questions as they come. Ms. Turner.
Thank you, Mr. Collier.
I was impressed. You're a first-year student. You've done a bit of this.
One assessment of this kind, yes, in contracts.
What about before coming to university?
So I was previously studying arts, and at the moment I do something entirely unrelated, working in a bakery, speaking with customers who may or may not be more terrifying than Your Honour, but only by a slim margin.
Only basically. Look, I thought you spoke very well. I like your use of language. Your voice has a precision about it that to an old-fashioned fellow like me is really quite attractive. And I thought that part of it you did well. You were courteous. You dealt with my questions well. You dealt with the special disabilities in the exchange we had, I thought, very well. Your aspect of the law, I thought were strong. They demonstrated to me strong and focused research. You spoke of the imbalance and dealt with that aspect well. I thought for someone who I now know hasn't done a great deal of this sort of thing, you did very well indeed. Please keep doing it.
Thank you.
Ms. Duncan, you spoke well.
Thank you.
You always do, because we're not completely new to this, are we?
No.
You knew where you were going and you went there, you did it within your time, which is important in these contests. And you left me with the feeling that you were master of your own fate, that you knew where you were going, you were presenting, you were being persuasive. And that's the art of this sort of thing, to persuade. So that part of it was very well. I thought you developed your legal arguments well. You dealt with puffing. Pardon me for a moment while I read my score. You talked about honesty at one stage, which I thought was telling. And overall, I thought you presented an argument which was all about the best you could do. All about the best you could do. I think it was a good performance, both in law and presentation. You dealt well with the first set of questions, and you had just a little bit of difficulty with the second set, but all in all, I thought you did very well on that.
Thank you.
Mr. Tien, you spoke well, but you tended to speak quickly. I don't know whether that was excitement. I hope it wasn't. I thought your work on the law was good. I thought your use of cases was strong. I thought that you spoke about the cancellation policy correctly and used the analogies that were available to you. Where I'm afraid I had to make serious deductions was in your ability with the questions. Not so much the answers you gave when you got there, but it seemed to me that you were determined not at first blush to answer the question I asked you. Now, if that was a misunderstanding caused on my part, I am very sorry. But it seemed to me that you would not come to grips with the questions as I asked them of you. All in all, though, a good performance. All of you should be proud of yourselves. I know at this time, well, I don't know at this time of the year. I can only imagine at this time of the year the cost in time that this is put upon you when you've got other things. I see nods, yes. And for that, you are to be truly congratulated. All of you, I think, can do well in this field if you choose to. If you ever want to come and do advocacy with me, I'd love to have you. Thank you very much for your performances. It's been a pleasure and a privilege to be asked to participate in this. Thank you. Back to you, Ms. Sharon.
Thank you, and a big round of thank you to our judges as well. Thank you for giving up your Monday evenings and the first day of potential freedom here in New South Wales for those of us who are doubly vaccinated. And to come and judge this round of the competitions, your insight has been invaluable and will be of great use both to these students, congratulations, incidentally, as well as to anyone who will be watching the recording of this. So thank you very much, and we hope you enjoyed your evening here with us.
I did.
Thank you.